General was at his best. What he does best, the only ye pa and our ye no say yemra media no so. Na ye me bua enkofo for yemra media no so. Na yen sentencing enkofo yemra media no so. Na yen pronounce enkofo guilty. That is his talking tree or yedi yankasa. And today he was at his best. The brand now on Samson Ayine AD and Komo. Yo, an attorney general, the first step, will take here. Being sworn into office as the mouthpiece of someone who is going to deliver justice for this country. And it's obe enter, nolly prosecute on various government cases involving Abenya Watisu appointees. The $200 million saglemi scandal involving the Honorable Elijah Collins Dowda, the 2.37 million euro ambulance scandal involving the Honorable Casey Lato Forcing, the over $20 million National Communication Authority scandal involving Ernest Thompson, the banking sector cleanup scandal involving NA Bank of Ghana Governor Esiama, Dr. Kwabena Dufour, and it goes on and on and on and on. And then Lawyer Samson Ayine, it was an interesting question. Say, in all the cases or intent to nolly prosecute, or no back on Egyptian Asopa, the $200 million saglemi housing scandal. And now, Lawyer Ayine Neka say, Yakwaji $200 million euro, free Swiss bank as a loan facility. See the BC 5,000 houses. A we actually know. A dana $200 million in one assam. And until now was to say, never sent Attorney General talk us on over here in ye kumuni faraba. Lawyer Dominic Ayine say na ensese aban no sa breno a prosecutor to be disallow Collins Dowda because a bro be dean works in housing ministry near. 2 or no dear. Then the Juma dear in say obey effective payment upon instructions from consultant constructura OAS normally responsible for the construction of housing is FAO. Very, very interesting analysis. Attorney General say consultant constructura for the farm and an report to the Ministry of Health and Housing. And the ministry the na why say consultant in the bar or say constructura for juma di amodishia wonsa omo sidan na duruse omo ye juma na duruse pempenso omo ye juma eduri omo deserve ebia $50 million. Inti according to the Attorney General, Works and Housing Ministry na omo ni any oversight responsibility with respect to inspecting someone na consultant ne kasa ye no kura na se enya no kura sa no matueska to mo dia ne se consultant ba no se constructura ye adwuma 40%. Sika omo deserve for the 40%. Na ministry ne twa dia mo nti adwuma alaji Collins Dowda nti ye po bia prosecute no na wo se MPP aban e prosecute consultants ni mo nti susuan pa se a whole ministry ya consultant lazy for a company was subletted a contract of $200 million jama. Now utumi tra homa consultant ebe da wo say adwuma na duru sei enti tuasika sei na ministry ya wo chief directors e wo inspectorate unit etumi tuasika e de ma this company through the consultant ministry whole ministry and to me enye proud inspection with respect to someone consultant take dia na anodin na emu wrem this and many more. And now the Attorney General Dominic Ayine kan ya na chese edru baby na ye no gwasesa ti yanko ayinkuti
this to the state attorneys who were involved. I believe in their professionalism and I respect their knowledge of criminal law a lot. All right. In fact, some of them are better than I am when it comes to criminal law. But I did an objective assessment, and so I give the saglemi case as an example. Now, if you look at the case, they were talking about $200 million, all right, of funds, that were misused, or loss to the state as a result of the actions of the persons who were charged, including my then client, Collins Dowda. All right. Well, we did an assessment of it. Collins Dowda was charged with causing financial loss to the tune of 200 million. But Collins Dowda was in the ministry for a very short period. At the time that he was leaving, only $94 million had been expended. Okay, so, I mean, something tell me, by what stretch of imagination can you charge a person like that with, with causing financial loss to the tune of 200 million, except to say that maybe his actions that, he took in office triggered the entire loss, all right? If you cannot directly attribute the entire loss to him, there was no point charging him with causing financial loss to the tune of 200 million. You know, but that wasn't even, as bad as saying that, he issued false certificates, okay? A minister does not issue IPCs, interim payment certificates, all right? The interim payment certificates are, issued by the consultants who go to the ground, assess the work done, all right, value it, and they say, look, this is how much, the state ought to pay to this person. Yeah, and then they are the ones who then write to the minister, and the minister just writes to Minister of Finance to say that, look, this IPC has been presented, please go ahead and pay. So unless they are saying that the minister ought not to have taken the advice of the consultants, okay, then you cannot attribute the false character of the IPCs, all right, to the minister, okay? So I did an objective assessment of
the minister
all
has supervision.
Yeah, you have ministerial responsibility, right, for your sector.
That's right.
Right. But when it comes to, technical matters, such as, a construction project, you have technical people working on and advising the minister. So I don't know by what means a minister is going to be able to say that this IPC ought not to be paid because it is false. That it does not reflect what is on the ground. When you have AESL, a government, a designated or a entity that does the professional work of consulting on government construction
ultimate
projects.
Responsibility, the buck stops with you. If you have to do due diligence to ensure that some wrong does not occasion us loss, and you fail, you should take the responsibility for it.
Well, I do concede that you should take responsibility for it, all right? But, criminal liability is specific. Can you actually say that the intent is attributable to the minister when you say that the certificate is false, right? What about the person who issued the certificate? Why were they not being prosecuted, as a result of, the determination by the then Attorney General that these certificates were false, all right? So the point I'm making is that I did an objective assessment of all these cases. And of course, if you take, Cocoa Board, the Opuni trial, as a lawyer, I'm sure you were following it. There was, reasonable doubt, a lot of doubt as to whether or not, right, the persons who were standing the trial were actually, criminally liable.
The question people have asked is, why don't you leave that decision to the courts?
Well, if I have assessed a matter, okay, and I have come to the professional opinion that this ought not to have gone to trial in the first place, there is no point wasting the state's resources in conducting a trial when I know that down the line, all right, the state is going to lose. That will be reckless. That will be professionally, and in fact, it will be unethical on my part to assess a matter, come to the determination that there is reasonable doubt, the evidence doesn't stand up, and then I say, okay, you know what, just so that I satisfy, the public, let this, continue. No Attorney General should be conducting himself or herself in that way.
The rules of ethics bind you in that regard.
Yes.
That even when you see that there is exculpating evidence,
I have to turn
some
it over,
form of evidence that will lead to the person you are accusing being freed, you should let them have it.
Yeah, I will have to turn it over to them.
Right. Nonetheless, there was loss, and the case is now gone forever?
Well, okay, so which one are you talking about?
Saglemi.
In the case of
Saglemi.
Saglemi.
Yes.
Okay, so the loss was actually estimated by the then Attorney General at 200 million, right? What they did not do, which is also very important, was to take a value of the built environment. That was never done. Okay, so it isn't as if the entire 200 million was not spent, profitably towards the project, right? Buildings were erected, the glazing was done. In fact, most of them were completed, road network, electricity and everything, all right? A diligent investigator, a diligent prosecutor ought first of all to have valued the built environment and then come to a determination as to how much was actually spent. Then you can say that if it falls short of the 200 million, then you say, okay, so out of the 200 million, only 50 million was spent on the built environment. 150 million was lost to the state. And so we want to recover that, want to prosecute people for that. And you have to deal with it with specificity. So the consultants, and persons who were responsible for, the construction and so on and so forth, like, the contractor will all have to, take responsibility for it. Okay, so yes, the